Hello, everyone. Welcome to Chapter 9. In this chapter, we'll be addressing the legal system. We have three video lectures for you, and we're going to start with this one, which will introduce you to the legal system, contract law, tort law, and other topics. Okay, as we talked about, this is introducing you to the legal aspects of health information management. We'll talk about such things as some basic legal and regulatory terminology. We'll talk about HIPAA, and we'll talk about release of information processing, what's a reportable condition and event, and the use of specialized health information. First, let's talk about civil and public law. Basically, a law, also known as a statute, is a rule of conduct. It's passed by the legislative body, the Congress under federal law, and it's enforced by the government, and it results in penalties when there are violations. Civil law deals with the legal rights and relationships of individuals. This includes torts, meaning a wrongful act that we can have a civil suit on, or contracts, which is a binding agreement. And we get into issues when one party doesn't follow the binding agreement. Public law deals with relationships between an individual and the government. This could be the state, local, or federal government. And criminal law deals with violations of these public laws that deal with the relationship between an individual and the state. Let's talk about a civil lawsuit. An individual who initiates a civil complaint has to prove it. In other words, they have the burden of proof. That person is the plaintiff. The defendant is the person who the complaint is brought against, and he has to defend himself against these accusations. Discovery is the legal process that lawyers use to obtain information about whatever happened. It's basically give me your side of the story. And this could be an interrogatory where there's a list of written questions that have to be answered in writing, and the parties swear under oath that the answers provided are accurate to the best of their knowledge. And a deposition is when somebody is deposed. So they come in and they give sworn testimony on something. The type of civil legal actions that most typically happen in the healthcare industry are torts and contracts. Sources of law include such things as administrative law, case law, statutory law. Administrative law has all the regulations that are created by the administrative agencies of the government. Regulations interpret how a law is to be enforced, and they are generally much more detailed than the law they are based on. Federal regulations are issued in the Code of Federal Regulations, which is subdivided into 50 titles and has all kinds of chapters, parts, and sections. Case law, otherwise known as common law, is based on judicial decisions and precedent rather than on statutes. Case law could be res ipsa loquitur, which means the thing speaks for itself, meaning that something is self-evident. Res judica, the thing is decided, meaning that the final judgment of a competent court is conclusive. Respondeat superior, let the master answer, which means the employer is responsible for the actions of their employees. And then stare decisis, stand by things decided, which means a doctrine of a precedent will influence this situation, right? And then we have subpoena ad testificandum, condom, candum, excuse me, that requires the individual to appear in court. That's different than a subpoena says take them, which means come into court with your documents. Statutory laws are passed by the legislative body. Federal law, that would be the Congress, and it can be amended, repealed, or expanded by enough votes in the legislative body. A statute of limitations refers to the time period after which a lawsuit cannot be filed. Medical malpractice results when a healthcare provider acts in an improper or negligent manner and a patient's injury, damage, or has a loss. Negligence is the failure to exercise a reasonable degree of care under the circumstances which resulted in an injury to the other party. Providers are required to have malpractice or medical liability insurance, which pays the lawsuit covered damages and defense costs, meaning legal cost. The medical record, as we've talked about in earlier course lectures, is a legal business record that has to be maintained according to accreditation standards and legal principles. So to be considered a legal record and have it be admissible as evidence in court, it must be created by a person within the business who has the knowledge of the acts, conditions, diagnosis, events, and opinions documented. It must be documented in the normal course of business. So we must keep them on all patients who are admitted, for example. It's generated at or near the time of patient care, and it's maintained in the regular course of business. Most states have adopted the federal rules of evidence and the Uniform Business Records as evidence, which accepts records maintained in the regular course of business as an exception to the hearsay rule. EHRs are also admissible if they meet the Comprehensive Guide to Electronic Health Records guidelines, which means that the type of computer used is accepted as standard and efficient equipment. The method of operation to create electronic medical records is recorded. The method and circumstances preparing the record include sources, procedures, methods, controls, checks, and information documented in the EHR has not been altered in any way. If we do all that, they are admissible as evidence in a court of law. Related to this, we have confidentiality and HIPAA privacy and security provisions. Any information that's communicated by a patient to a healthcare provider is considered privileged, meaning private. Patients have the right to confidentiality, which is the process of keeping privileged communication secret, and means that that information cannot be disclosed without the patient's authorization. A breach of confidentiality occurs when the patient information is released to others that don't have a right to access it. According to the HIPAA privacy and security provisions, patients have the right to an expectation of privacy regarding their privileged communication, which means information cannot be disclosed without their authorization. Safety safeguards must be implemented to ensure the facility's equipment and patient information are safe from damage, loss, tampering, theft, or any unauthorized access. More about HIPAA. HIPAA is the first federal law that governs the privacy of health information nationwide. It was created and organized according to 5 titles. Title I covers healthcare access, portability, and renewability. Title II covers preventing healthcare fraud and abuse, administrative simplification, medical liability reform. Then we get into tax-related health provisions in Title III. Title IV addresses application and enforcement of group health plan requirements, and Title V covers revenue offsets. HIPAA resulted from the Clinton administration congressional efforts to reform healthcare by enabling workers of all professions to change jobs even if they had pre-existing medical conditions. It seeks to reduce healthcare fraud and abuse and reduce paperwork associated with healthcare claims processing. It guarantees the security and privacy of health information, and the portability aspect of HIPAA protects health insurance coverage for workers and their families when they change or lose their jobs. The accountability aspect protects healthcare integrity, availability, and confidentiality. And it's this accountability aspect that has the greatest impact on healthcare organizations, particularly health information management departments. And that's all I have for you. Come back for our next video lecture where we'll be covering more about HIPAA and more about the different aspects of health information management and the legal system. We'll see you then. Bye now.